Investors owe each other different fiduciary duties depending on the type of company involved. In McLaughlin versus Schenk, the Utah Supreme Court considered what fiduciary duties shareholders in closely held corporations owe each other. Greg Schenk and his father, Boyd, founded Cookietree Incorporated in 1981. Greg Schenk was Cookietree's president, while Boyd was its majority shareholder. In 1992, Schenk hired Samuel McLaughlin, who had substantial industry experience. McLaughlin was hired as an at-will employee, compensated with an annual salary and stock options. McLaughlin was later promoted to vice president and became a minority shareholder in Cookietree by exercising his stock options and using his personal funds to purchase shares in the company. After Boyd died, his wife Anna transferred his Cookietree shares to Schenk in 1999, making Schenk the company's majority shareholder. McLaughlin later expressed interest in buying the company from Schenk, but failed to raise the necessary capital. Schenk and McLaughlin's relationship later soured, and Schenk fired McLaughlin in 2004. Under the terms of McLaughlin's current employment agreement, his termination date wasn't effective for 6 months, allowing him to continue receiving compensation. However, when McLaughlin was immediately relieved of his duties and blocked from Cookietree email, he refused to leave the premises and had to be escorted off-site by police. McLaughlin subsequently sued Cookietree and Schenk for breach of contract and breach of fiduciary duty. In 3 separate actions based on McLaughlin's termination, Schenk's acquisition of his father's stock, and a derivative suit. The trial court consolidated the 3 cases. McLaughlin argued that Schenk owed him a fiduciary duty because he was a minority shareholder in a close corporation, and that Schenk breached that duty by firing him. The trial court granted Schenk's motion for summary judgment. The court found that Schenk owed McLaughlin no fiduciary duty, that Cookietree terminated McLaughlin, not Schenk, and that Schenk's stock acquisition didn't violate the shareholder agreement. McLaughlin appealed to the Utah Supreme Court.